Alexander Cole here. What are we doing with Cole? I don't see Etheridge. Etheridge is here. What are we doing with Alexander Cole? Cole's on. It's Miss. It's Miss. Oh, okay. We don't know what we're doing. George is right outside that door. If you open that door, Mr. Ned. What are we doing with Alexander Cole?
Your Honor, we don't have necessary witnesses. Knowledge.
Okay, he waived his appearance. You can go and advise him. On the record in the matter of the state of Michigan versus Alexander Cole, 26-00553 FY appearance, please.
Thank you, Your Honor. Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
George and APD on behalf of Mr. Cole is downstairs at line.
Today was a date scheduled for preliminary examination for assault with intent to do great bodily harm less than murder. And then there's a misdemeanor assault and battery. There's no witnesses here.
Yes, at this time, Your Honor, we have reached out to the witnesses. We have asked that they appear today. They still have not shown at this time. We are dismissed the case with the intentions to refile if we can get the contact.
Okay, so motion dismiss without prejudice. I'm sure you're not objecting, correct? Okay, we'll get you a nominee and then we can take it down to him when you get an opportunity.
Thank you.
Thank you. State of Michigan versus Lance Richmond, 25-02015, 25-02158.
Thank you, Your Honor. May it please support Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant in case number 25-02015 FY.
Okay, today was the date scheduled for preliminary examination on this matter, or for a plea actually on that file. I think on this other file, we received notice from Mr. White's office of a family emergency prohibiting him from appearing today and requesting an adjournment. The timeline already had been waived, so we'll reset that matter. What are we doing with your case?
Your Honor, if you don't already have in a file, I have an advice of rights and a plea sheet for today on my file. I can approach.
I can have a date for Mr. April 17th at 8:30. April 17th at 8:30.
Your Honor, can we get 2 copies of that? One for Mr. White's assistant who was present today.
Okay, so on this matter, 25-02015, the defendant is going to plead guilty to use of a controlled substance under NCL 333.74042A. That's a misdemeanor. Maximum penalty is 1 year and or $2,000 in fines. And then there's a killer brew to no upfront jail. Is that correct?
That's correct, Your Honor.
It is, Your Honor.
Says here defense has checked the jury trial.
Oh, Your Honor, I was just filling it out as I usually do when it comes to, but yeah.
Got it, okay. You want to accept that offer and plead guilty, sir?
I do, Your Honor.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, sir.
Okay, and this is an advice of rights and plea information sheet with today's date on it. You've gone over these rights,
I
correct?
did.
You understand all the rights here?
I do.
You're willing to give up or waive these rights today in order to plead guilty to use of a controlled substance?
Yes, sir.
So you understand that as you stand there today, you are presumed innocent until proven guilty. You can maintain your innocence. Take this matter to jury trial and require the prosecutor to prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial and not have silence be used against you. the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses that will testify on your behalf or present evidence that you believe show a defense to the charges being brought against you. You also can waive your silence at trial and testify on your own behalf. You understand those rights?
I do, Your Honor.
Is anyone promising you anything to get you to want to waive those rights and plead guilty?
No,
Any threats being made to you
no,
to make you want to plead guilty?
no,
Are you currently on probation or on parole?
no, Your Honor.
You understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer, or you may need to report it on a future job application.
Yes, Your Honor.
It also could have impact on where you can travel or get immigration status. You understand that?
I do.
As to use of controlled substance, are you looking to plead guilty to that because you believe you are guilty of it?
Yes, Your Honor.
Okay, how do you plead?
Plead guilty. Your Honor.
Factual basis?
Thank you, Your Honor. All right, Mr. Richmond, on July 7th of 2025, at or near East Saginaw Street and North Grand River Avenue in the city of Lansing, were you present at that date and time in that place?
I was.
All right, and around that place or around that date and time, did you knowingly or intentionally use a controlled substance?
Yes.
All right, and what was the controlled substance? Okay, and did you have a prescription for that?
No.
All right. And you knew it was Adderall and that you didn't have a prescription when you were using it?
Yes.
Your Honor, I have no further questions.
Any question from the prosecution?
Your Honor, we just would address that she missed a portion of the venue. Is that place?
Can you speak up, please? We have fans running. I need you to speak louder.
The defense attorney missed a portion of the venue.
You can just ask the question. That's why I asked you if you have any questions.
Is that in Ingham County in the state of Michigan?
Yes.
Very good.
We're
Okay.
satisfied, Your Honor.
Thank you. The court is also satisfied with the factual basis. I'll accept your plea. Find your plea to be free, voluntarily and intelligently made. Matter is scheduled for sentencing on May 7th at 9 o'clock in the morning. When you leave here, you're going to check in with probation so they can get you set up for a pre-sentence interview. You also must undergo a substance abuse assessment, okay?
Yes, Your Honor.
You have any questions at this time?
I know, Your Honor. Thank you.
And you received your notice to appear for your preliminary examination, correct?
I think I'm waiting.
Yes,
on
he
that
has
one.
he has the preliminary exam.
I have the prelim, yes.
Okay, and then you're waiting for the notice for your, I'm assuming your sentencing.
Yeah.
Okay, you can have a seat and then they'll take you down to probation in just a moment.
Okay, thank you.
State of Michigan versus Octavia McCray, 26-00575. Appearance for the record, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan.
Jacob Riley on behalf of Ms. McCray. Your Honor, Ms. McCray is not here. However, I was able to verify that she was taken into custody in Isabella County yesterday.
Isabella County. Some that the court's going to find good cause to go beyond the 21 days. We'll reset this with writ, to writ her from Isabella County.
April 17th at 9.
April 17th at 9. I'm gonna revoke the bond just to make sure that we can get her on the grounds. Any additional matters for the record?
Nothing from the people, Your Honor.
Oh, Your Honor.
Thank you, you're all set. State of Michigan versus Michael Tishalumba, 26-00574.
Thank you, Your Honor. May I please report Dan Smith appearing on behalf of the people of the state of Michigan.
Jacob Riley on behalf of Mr. Shalumba, who is not here, and I have not been able to reach him.
Okay. I'll issue a bench warrant bond forfeiture. State of Michigan versus Jerry. Gary, is he downstairs?
He is, Judge.
Okay. What was the intent with that?
We'll be running this one.
Okay, I'll call it in a moment. State of Michigan versus Travis Graves, 26-00616.
Thank you, Your Honor. May I please report Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Jacob Riley on behalf of Mr. Graves, who is present to my right.
Mr. Graves is scheduled today for carrying concealed weapon preliminary examination. I have a note here that he intends to unconditionally waive to the circuit court.
That is correct, Your Honor.
That is our understanding, Your Honor. We will unconditionally waive and move this matter to circuit court.
Any offer at this time? Or are negotiations pending?
We have made an offer to be as charged under hiding, Your Honor.
Okay, Mr. Graves, you do understand that you have the right to have a preliminary examination?
Yeah,
Oh, is that a yes?
yeah,
Yes.
yes,
Okay. And then you also understand the purpose of the preliminary examination?
yes, I do, man.
Okay, so you have the right to have the prosecutor establish that they have sufficient probable cause that the felony you're being charged with, which is carrying a concealed weapon, was committed, and then sufficient probable cause to charge you as the person who committed that felony. You wish to unconditionally waive that examination?
No,
You don't want to waive it? We can have your hearing.
I don't want to waive. Yeah,
He has the right to have his preliminary examination.
Yes.
Okay. No worries. And your witnesses are here?
I need to double check, Your Honor. I know I spoke with
We can go check now.
his counsel.
There's about 3 representatives from the prosecutor's office in here right now. Somebody can go check.
He spoke with the defense counsel earlier today and he was gonna waive, so we just need.
Doesn't matter. You don't, witnesses don't get excused until the court excuses them.
no. I think it's-
He has the right to have his exam.
I don't know what he's saying is.
You just wait, to see if there's a witness.
Yeah.
We do not have the necessary officers to move forward with
Come back
the
up.
case at this time, Your Honor. But
Your Honor, I just checked, this is Ross Marchmina. I just checked our system and for some reason, it looks like our subpoenas did not go out to the officers in this case. So if the defendant does wish to conduct his exam, we would request an adjournment so that we can properly subpoena the officers and ensure in advance that's the entire service.
We want to see.
Your Honor, I think My client wants to run this exam, we do not object to it, request an adjournment for that reason.
Okay, so they did not subpoena a witness for whatever reason. And so I'm going to find a good cause to reset this because it appears, sounds like if it was dismissed, they probably would reissue it against you, which means you have to be rearranged. I also am gonna applaud you for considering it. You never waive your rights if you don't feel comfortable with it, okay? You're not gaining anything by waiving a right. You understand that? Especially in this instance, the offer is HYTA.
Yeah,
It's not a,
it was the first time. So
Yeah, oh,
I
no
didn't
worries.
know.
it does, no worries. Let your attorney do his job. And so we will reset this matter so that subpoenas can go out. And then you can have your hearing and your attorney can figure out or
I would
ask,
like
or you
to
no, you don't
speak-
speak. I'm gonna remind you of your rights to remain silent so that nothing can be used against you, okay?
April 30th at 9:30.
April 30th at 9:30 is your due date, okay? Do you have any questions for the court?
No,
Okay. Any additional matters?
No, nothing from the people.
Okay. You sure you don't have any questions? You look like you do.
This time,
even if I have a question, I don't know how to put it. Or.
Well, maybe go talk to your attorney in private and run it by him, and then he'll help you formulate your question. How about that? And then you can come back if you still have a question.
thank you, Your Honor.
You're welcome.
Jacob, I'll bring my notes up.
State of Michigan versus Albert Kemper, 26-000056. Your assistance.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Kemper.
Okay, Mr. Kemper was scheduled for sentencing today. Get a restitution hearing. Are we holding a restitution hearing?
At this time, Your Honor, I've been informed we don't have any information on the restitution, so we won't be pursuing that at this time.
Okay, so I do have a pre-sentence report that was prepared back on the 10th of March. Council, you both got a copy of that.
Yes.
I did.
Okay, any reason to make directions, updates, or deletions?
None from the defense.
People have nothing to add.
Okay, you can make that application.
Yes, Your Honor, we'd ask the court to follow the recommendation and sentence Mr. Kemper to a term of probation in this case. Mr. Kemper has taken steps to try to get back on track. He's currently enrolled at PATS. He had his first class yesterday. And so getting him into treatment, he's been working with the social worker from my office and making steps and progress towards that. So I think he would be an amenable candidate for probation and is willing to do the work that would be required for it.
Right, want to make a statement today?
He does not, Your Honor.
And the victim is not present today, correct?
The victim is not present. Your Honor.
And it does look good when you see victim. Okay. I am reviewing your prior criminal history and the report, which the recommendation is for a term of 18 months of probation, to include intensive outpatient treatment that would address the underlying issue of being a substance abuse, alcohol abuse issue. For you to continue or to attend 12-step meetings and to participate in random testing. I think it's appropriate under the circumstances. And so I will adopt the report recommendation and sentence you to 18 months probation. While on probation, you will be ordered to continue your treatment and care at PATS, okay? You are required to attend a 12-step program as recommended or as directed by your probation officer, and to participate in intensive outpatient treatment as recommended. You're not to engage in any assaultive or threatening behavior. You're not to have contact with Mabel Rayler. You're not to possess any alcohol, marijuana, or controlled substance unless you have a valid prescription. You understand that?
Yes, ma'am.
You will be required to submit to random preliminary drug testing and urinalysis testing, and you have to pay the cost of that. And you're not to be in any bars or nightclubs while on probation. You have any questions so far?
No, ma'am.
Why are you not employed?
I'm on disability. I've had 13 surgeries since 2006.
There's a $75 time victim rights fee plus a $50 state minimum cost. Plus $540 for probation oversight, this is $30 per month for probation. So your total fines and costs, because I'll waive the additional discretionary fines, will be $665, and you'll make monthly payments on that, okay? You are on a term of probation for domestic violence. You do not have the right to early discharge from probation. Do you have any questions at this time? You'll report monthly to probation and you'll check in today before you leave with your probation officer, okay? Any additional matters for the record?
Nothing from the people, Your Honor.
Your Honor, we would ask that Mr. Kemper's tether be removed at this time. He's been on tether for this entire time. He's had no violations. I think he's shown by taking steps to already get started with classes and everything. He's serious about probation. He's on supervision. And we're not asking for the no contact order to be removed, just the tether. It is a financial burden for him.
I was just saying, when was tether or it's not marked on the file.
When we came to court the last time, back in February.
I didn't see you in February. It's like I saw you in January.
Oh, it was a condition of release in January.
Oh, I did see that. I see, okay. He was in custody, is that what happened?
That's correct, yes.
Okay, tether can be removed. We'll notify GSG so that you can go have it removed, okay?
Thank you.
Thank you.
Yeah, it was, I have these bonds.
Me?
State of Michigan versus DeMarco Mayfield 26-00006.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Attorney Derek Betts from the Office of the Public Defender on behalf of Mr. Mayfield.
Your Honor, Mr. Mayfield is not present. I did try to get a hold of him this morning. I called his point of contact number and spoke with his mother. His mother advised that he thought it was on the 30th. She was at work and couldn't get in contact with him. He did show up and have his PSI completed. I think for the most part, he's been compliant on bond up until today. I would ask the court to consider rescheduling it, or if the court is going to issue a bench warrant, ask the court for 48 hours so he can try to turn himself in.
Until the end of the day to appear for his sentencing, or I'll issue a big short today.
Thank you, Your Honor. If he does appear, will it be rescheduled?
If he appears today, we'll sentence him today.
Thank you, Your Honor.
He could have appeared via Zoom. He doesn't have to appear in person
He can appear by Zoom, Your Honor. Thank
for
you.
sentencing. Yeah. Let's see, State of Michigan versus Christopher Wise, 26-00048. Appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan.
Aaron Robinson, Assistant Public Defender for Mr. Wise.
Okay, Mr. Wise has a sentencing scheduled for today. We have a PSI that was prepared on the 10th of March. You both got a copy.
Yes, Your Honor.
I have.
Making any updates, corrections, or deletions?
People have nothing to add.
We are as to the employment section. Mr. Wise is now employed, and remind me of the company again.
Right.
Ryder, he's employed at Ryder now.
What do you do?
What do you do?
High-low driving.
Oh, driving.
Yeah.
This is good drive.
Yeah, I just drive.
I was like, I
Fine.
don't know
That
what
works for
high-low
me.
is.
I don't either. Okay, any other updates?
No, Your Honor.
Make allocation.
Yes, Your Honor, we'd ask the court to sentence Mr. Wise to a term of probation as indicated in the pre-sentence investigation report. Mr. Wise has made some progress since picking up this case. He's currently involved in AA and has his sponsors here in court. He also has significant family support as well, who is with him. He's since become employed. I think he is making steps and is involved in getting into classes, behavioral therapy classes that would likely be required for him as part of probation, and just making steps to improve himself, even if it wasn't required for probation. But I do think he would be an amenable candidate for probation.
Did your client want to make a statement today?
He does not, Your Honor.
I reviewed the pre-sentence report and the recommendation, which is for a term of probation, as well as the defendant's prior criminal history. We don't have a victim here today, do we?
No, Your Honor.
I will adopt the recommendation of the sentence or the defendant to participate 12 months of probation. While on probation, you have the following conditions. I'm going to order that you continue AA. However, you do need to complete a substance abuse assessment if you have not done so recently, okay? If you've done one recently, you can just have that released to your probation officer. But you need a substance abuse assessment, and then you're required to follow all the recommendations, okay?
Okay.
You have a question?
No, Your Honor.
Okay. And so you are going to also be ordered to participate in complete batterers intervention. Maintain employment. I'll continue the no contact order with Stephanie Wise. I'm assuming is that your spouse?
Yes.
She's not appeared here to request that to be set aside, so I'm gonna continue. You're not to engage in any assaultive or threatening behavior. You're not to possess or use any alcohol, marijuana, or controlled substance without a valid prescription. You will be required to submit to random preliminary breath testing and your analysis testing. You're responsible for the cost of that, okay?
Yes, Your Honor.
And you're not to be at any bars or nightclubs while on probation, and I will grant 769.4A. There's a $30 per month oversight fee that you're responsible for, so there's $360 for probation oversight fee, plus $75 time victim rights and $50 statement of costs for the waive discretionary fines and costs. It's $485. You'll make monthly payments on that, okay?
Yes, Your Honor.
Do you have any questions at this time?
No.
You're gonna report monthly to probation. I'll have you check in with your probation officer before you leave here today.
And Your Honor, we would be asking for a tether removal on Mr. Wise as well. Sorry, I saw you with the file. We would ask that his tether be removed at this time. It is a financial burden for him. I don't believe that he's had any violations of the contact order while on bond for this case. And now that he's been sentenced to probation, he will be under supervision.
Your request is granted. We'll remove the tether. We'll notify JSG so you can have that removed, okay?
Thank you, Your Honor.
You have any questions?
No.
Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you. And what are we doing with Robin Holstein?
She is present outside, Project Aaron.
Are we running? I saw it, no? Or no?
Court's indulgence, can you give us a second?
Yes, go ahead. Yeah, but I didn't get any people. And then I. Right.
Policy on Monday. You did. They just sent it to me from 1:30 to 3. Like, you know, they just sent it to me. Yes. Who they think it is? scheduled for like trials or something.
We had a lot of trials, a lot of them.
On traffic matters. Very
Lot of them
serious,
taking a plea.
very serious trials. is going on.
Half of them are taking pleas.
All of them will be. I'm not writing a trial on traffic.
Well, escapes is not traffic.
So, maybe. Is this Ms. Holstein?
It is.
Okay, State of Michigan versus Robin Holstein, 26-00166, appearance please.
Ross Marchmino for the people.
Aaron Robinson, Assistant Public Defender for Ms. Holstein.
Okay, today was the date scheduled for a preliminary examination. An assault with a dangerous weapon. There's also domestic violence aggravated. How we proceed?
So Your Honor, it's my understanding that Ms. Holstein has been accepted into the 55th District Court's mental health court program. However, we're both going to be requesting that the exam be adjourned so that we can circulate a memorandum of understanding to facilitate transferring the case to 55th.
No, yeah, but that was the note that I had on the fourth, and we were awaiting paperwork, so I guess we still don't have that.
That's correct, Judge. So it was my understanding that it would be sent 2 weeks ago. I didn't hear anything back from the prosecutor. I was out all last week and the Friday before on medical leave.
Okay.
So I just wasn't able to follow up until now. I apologize.
No, this was set up for another problem. So follow up on the paperwork.
Thank you, Judge.
Thank you.
Sure. How long do you think it's gonna take?
We can get the paperwork today, probably like 2 weeks max.
2 weeks should be plenty. We just need to get signatures on the review.
April 10 at 8:30. April 10 at 8:30.
8:30, you said?
Correct.
Thank you.
Get the paperwork before that, then obviously she does not need to appear because the case will be transferred.
Understood.
Any additional matters for the record?
Nothing for the people.
No, Your Honor, thank you.
Thank you. Okay. And what are we doing with Vu?
Yep.
Are we writing an exam on that?
We're not gonna be prepared to run the exam today. Our officers that were listed on there have not shown, so
Your officers didn't show? They were subpoenaed?
we're gonna make a motion.
Who was the officer? I have a list.
Officer Gubri and Staley.
Your Honor, they were county deputies. My understanding is that Deputy Staley actually responded to the warrant, but Deputy Dewberry MIA without an explanation, which obviously is not a cause to adjourn the exam.
You said I couldn't hear your voice drop, so what?
Sorry, an officer not appearing on a subpoena, of course, is not good cause to adjourn the exam.
This is State of Michigan versus Vu 26-00584. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
George and the APD on behalf of you, Your Honor. Your Honor, I just want to be honest with the court. I think Officer Gubri is here, but the officer conducted the stop is not here, to my understanding.
Okay, so you have one officer here.
One
Maybe, I could be wrong.
Yes, one officer is here who tested the drugs, but again, the officer.
Officer conducted the stop is not here. And officer who is here doesn't know why the other officer's not here.
All he did, all his responsibility was testing.
No, I'm saying he doesn't know where his colleague is.
Okay, you know what, Your Honor, I was under the impression that Gubri was not here. The officers we have subpoenaed are Gubri and Staley, so I suppose the necessary officer was not subpoenaed.
Okay, I'm gonna let y'all figure that out and then I'll call it again. I'm the attorney, scissors and tape to figure out the, I don't know.
I don't see a trend.
In the meantime, let's see.
This is every, this is a every day. I couldn't do it.
Just gonna do a couple more while you wait. Got time.
Might be a man.
Person who's supposed to be-
Mr. Etheridge, all. You leave? No, he's on. Is that Mr. Etheridge right here? Mr. Etheridge, your client is on Zoom.
Thank you, Your Honor.
You need to speak to him.
I need to speak with him. I did not get the PSI delayed yesterday, and I will never get in contact with him.
No.
Oh, his mom. Your attorney's gonna log in to meet with you right now, Mr. Mayfield.
Okay.
Yep.
Okay, let's do this. Mr. Annette is filling in for this one. This is you. State of Michigan versus B Blue, 26-00584. Appearance, please.
Ross Marshmina for the people.
George and Ed for Mr. Bibiana.
Okay, and he is presently in Ingham, downstairs in lockup, correct? Okay. And then this was scheduled for controlled substance possession. And we were trying to figure out if there were, the necessary witnesses were in fact subpoenaed.
So this is what we figured out. There were 2 officers we needed, and there were 2 officers that subpoenaed. Okay, but only one of the 2 officers we needed were among the 2 who were subpoenaed.
Awesome.
That officer was here, and then after some time elapsed and the case had not been called, he grew impatient and saw himself out of the building.
Oh,
Yeah.
awesome. This is how court works.
So he is no longer present. So in sum, we are not able to begin the exam as a result of the fact that an officer who was subpoenaed and was present has left the building, which I don't think I can argue in good faith is good cause to adjourn the case. And so the people will move to non-class.
Objection, Your Honor, thank you.
Okay. And he's obviously being held on something else, no?
He's in, yes.
Okay.
Yeah.
So a motion to dismiss without prejudice is granted with future knowledge for Mr. Lu.
Thank you, Your Honor.
And so Adrian Person, we're running that.
He's not here, Judge.
I think he's in custody.
Custody.
He's in custody? I thought
Custody,
it was
yeah.
released, I had information from his release.
So we're saying.
Well then, yes, we will probably be running it.
As of yesterday, he was in custody. Okay, Mr. Etheridge, are you ready with your client?
Yes, we are, Your Honor. Thank you.
Can you give me his file back?
That is.
The one that was sent to
Mayfield.
you? Mayfield.
Mayfield. Yeah.
I think he still is in the court somewhere.
Probably in the printer.
Oh,
okay.
So I heard something.
Does he pick up on a new case?
Okay, on the record in the matter of the state of Michigan versus DeMarco Mayfield, 26-0006, appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Attorney Derek Etherson is also the public defender on behalf of Mr. Mayfield. I'm appearing by video from the courthouse. Mr. Mayfield is also appearing by video.
Okay, today was the date set for sentencing. I do have a pre-sentence report that was prepared on the 18th of March. And counsel, you did get a copy, and I think you just had an opportunity to review that with your client. Do we have reason to make changes to the report?
Your Honor, there was only one change, and that's on page 1 at the very bottom, under employment data. It has that the box employed checked. It should be unemployed rather than employed.
Any other changes?
No, Your Honor, thank you.
Nothing from the people, Your Honor.
We don't have a victim here, I don't believe.
No.
Oh, you can make allocution.
Thank you, Your Honor. Your Honor, would ask the court to follow the recommendation. It would also ask the court to grant the special status of 7694A. Mr. Mayfield understands that is a privilege, and that if the court grants him that he will work hard in order to complete his probation and keep this a non-public record. It would ask to waive any fines or fees to cost the court can. He is unemployed. I would ask the court maybe to grant some community service in lieu of that as recommended by the report itself. Regarding other bond conditions, he would leave that up to the court's discretion. I did have the opportunity to address some of the concerns with him that's in the report regarding the ability to contact him. He did advise me he does have a workable email address. He was able to get back into his email account that he can provide that email address to his probation officer. He does have a contact number through his mother. That's how I've been contacting him. I've used it a couple times this morning, and obviously it worked because he did. I was able to get him here by video. She was able to get in contact with him. Regarding the ability to pay, he's in the process of getting a state ID, and he has been putting in applications for a job, but he needs to get that ID, and he will continue to apply for jobs and hopefully get a job. Currently, his mother's helping support him, and he advised me he would start paying or assisting with the rent and stuff with his mother once he does get a job. I know the report says that he's not remorseful for his conduct. I think he's still coming to terms with that, and education and treatment will help with that. But throughout my representation of him, he's admitted to this and taken responsibility to it with me. Would ask the court to take that into consideration and fashion an appropriate sentence. Thank you, Your Honor.
Does your client want to say anything for himself?
Mr. Mayfield, do you want to talk? If you don't have to, if you don't want to.
No, I think that was pretty good. Thank you.
Okay, well, Mr. Mayfield, help me understand why a man who's almost 30 years old and is a father, you have children, but you don't have a job. How does that work?
I had a job before the incident, but then I couldn't go back to the same job afterwards. So I would have a job more now, but my state ID and all my other information she has right now, and I can't get it from her. So I have to go through like old photos, so I could even get the picture from my state ID so I can redo that.
She has your ID?
Yep, my ID, Social Security, my W-2s. So I gotta redo all that.
Does the prosecutor's office have contact with her?
I believe we have good contact, but it's been several months since since we've had contact.
Okay, I'm gonna request that the prosecutor's office make contact to retrieve those items in her possession so that the defendant can have his governmental documents in lieu of me having to show cause for here. He's gotta get a job.
Yes, ma'am.
Reach out to her.
So you said she has your social security number and your ID?
Yep.
Okay. Okay, the court has reviewed the pre-sentence report. I do believe that you are eligible at least for status under 769.4A. It's only you who can determine whether or not you're gonna be a good candidate for it, because I don't see any other criminal exposure for you. This is the only thing that's been on your criminal history. And so we'll give you an opportunity to prove that you will be responsible. You will be required to obtain and maintain employment. Again, the court is going to take or make efforts to have the prosecution retrieve your personal items to help you expedite your ability to get meaningful employment. You are going to be ordered to participate in the batterers intervention program. I believe that, but the probation officer is concerned about his ability to get in contact with you because you don't have your own phone. But it sounds like right now you're getting communication through your mother.
I do have a phone, but my baby mama also has it as well.
And she's the victim in this case as well. The one that has your driver's license, Social Security.
Yeah, I'm assuming. Sounds like
Did
she's
I
calling
ask,
us.
did they ask about the phone as well?
I mean, I just would know she's obviously not here to respond to these allegations that I have a suspicion are not completely consistent with reality.
I don't see why he would make up that she has his ID and W-2. So I'm assuming they might have been living with each other. I don't know.
Yeah, we were about to. It was
Well,
like that.
she's never appeared for court, has she?
I don't think so, no.
So we're gonna need her to appear because we need to know if she has his things. And if so, she needs to bring them so that she can give them back. Or she can let the court know. I don't have them, I never have them. I'm assuming, were you living with her at the time of the election or the incident, I should say?
Yeah, yep. I think we're like 2-3 weeks in.
Okay, and so, you were arrested?
Yes, ma'am.
And you've not been to pick up any of your things?
No, they told me not to go over there, and yeah.
Correct.
And then
That's, I'm just making sure. It does state that there wasn't an option for you here, it looks like on the pre-trial release for you to go and retrieve your personal items. So if he was living there, his personal items are still there.
They may be there, we don't know, Your Honor, but I just got information from our victim advocate that she was actually here earlier today. She waited around, the case wasn't called, and she's since left the court. So we'll reach back out to her and have her come in.
Yeah, she doesn't, if she wants to work with the prosecutor's office to make arrangements so that the defendant can get his things, then she doesn't need to come back in. But obviously, the address that he had at the time, I think was her address. And so there was a no contact order. He was not allowed to return to that address. And so, and typically, sometimes the arraigning official will allow the defendant to go one time to retrieve their items. That was not an option on this one. So we just need to figure out how he can get his stuff. His personal items. And I'm assuming there could be arrangements made between her boxing up his things if she hasn't already done so. And then a third party maybe going to maybe his mother or somebody going to pick up those things. So we'll leave it up to the prosecutors since they do have good communication with or the victim's office to make contact and help facilitate that. And then you, Mr. Mayfield, will remain in contact with the probation department to confirm if you received your things or not, okay?
Okay. Okay.
And let's see here. You're again not to have contact with her directly or indirectly, unless there's a family court order that is entered, because I do believe that you all share two children, but that she has full physical custody, correct?
Mhm.
Is that a court order?
I'm not sure actually.
Did you go to court for custody?
I'm not sure if she did or not. I don't think so, but
Okay,
she may have behind my back. I'm not sure. I don't think so.
okay, okay. Well, again, if there's a family order entered that allows you to have your visitation rights, you can notify your probation department. It will make arrangements to have this order change so that you can make exchange for your parenting time. You're not to engage in any assaultive or threatening behavior. You're not to possess or purchase firearm, ammunition, or weapon of any kind. You're not to use alcohol, marijuana, or controlled substance unless you have a valid prescription. You understand that?
Yes, ma'am.
You will be required to submit to random preliminary drug testing. You have to pay the fee for that, okay?
Okay.
And you're not to be at any bars or any nightclubs. Do you have any questions so far?
No, ma'am.
I am, if I didn't say it, granting 769.4A. I'm also going to order that you participate in early education for alcohol and drug use, okay?
Okay.
There's a $75 crime victim rights fee and a $50 state minimum cost that will be assessed. You're going to be on probation for 10 months. It's $30 per month oversight fee that's assessed for each month of probation. So probation oversight fees will be $300. Your total fines and costs, because I will waive discretionary fines and costs, will be $425, and you can make monthly payments on that, okay?
Okay.
So you don't have the right for early discharge because you are on probation for domestic violence. You'll check in with probation. You need to make contact with them by Monday because they need to make sure they have an email and a way for them to contact you that's meaningful, at least until you can get your phone or retrieve your phone. Okay, sir?
Okay.
You'll be reporting monthly remotely via Zoom. Do you have any questions at this time?
You said monthly?
Correct.
Okay, cool. Gotcha.
Any additional matters for the record?
Nothing to add from the state, no.
Your Honor, regarding the jail time, is it as recommended, 93 days, credit 2568 suspended?
That's correct.
Thank you, Your Honor.
Thank
Nothing.
you. You're all set.
Thank you, Your Honor. Have a good day.
Thank you. State of Michigan versus Reddy Curtis, is that correct?
Reedy Curtis.
Reedy Curtis, that's 25-03-491, appearance please.
Ross Marshmino for the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Curtis. He is approaching council table currently to the jury box, Your Honor.
Okay, Mr. Curtis is scheduled today for preliminary examination on how clean vehicle, possession of narcotics, and several police officer assaults. Are we ready to run the exam?
Your Honor, basically, this is where we are in this case, and you're just gonna be really thrilled with how on top of everything we've been today. Basically, we have an officer who communicated to us in advance that she is on vacation this week and not available. This was not communicated in advance to the defense because I was under the belief that we would be able to establish the elements of the crime without her present. Upon conversation with Mr. Austin, he has legal arguments that he would make in favor of dismissal of the case without her testimony, and he's making some good points. I think you would probably be on his side on this one. So the people are going to be, we would be able to start the exam and then ask for a continuance. I think we're in agreement that the better route here would be to request an adjournment. And I do recognize this is a 180-day rule case and that we're up against the clock as it is. That's the hand that we've been dealt as of today, and I will discuss with the hires up in our office how to handle our 180-day timer.
You said an officer is on vacation, and which officer is this?
Caitlin Booth. She might be Caitlin Miller on that complaint.
I think it says Booth.
Says Booth, okay.
It's just. Yeah, it's this week, that's for sure. Okay, let's see. And she is essential to the police officer eluding or something?
Yes, she is essential to establishing the lawful nature of the police conduct.
Got it. Mr. Austin.
Thank you, Your Honor. And before I proceed, I don't know if it was placed on the record, but what is the extent of the officer's unavailability?
She will be back, I think, next Wednesday.
I understand the position they're in, but I mean, they certainly are not in a position to consent to any adjournments on behalf of Mr. Curtis. He is in Department of Corrections custody. He was on parole. He was taken back to the Department of Corrections because of this. He's on dead time and his 180-day clock is running. It sounds like he had advance notice of the witnesses' unavailability, as they stated, was not properly communicated either to defense counsel or to the court. I'm not casting any aspersions to say there's any kind of potential wrongdoing. I mean, I'm sure that
whether it was communicated or not, we have no control over the date that was set.
But nonetheless,
statutorily.
But nonetheless, it would have a prejudicial impact on Mr. Curtis, and so I'm not in a position to say anything.
So there's an objection from the defense. However, an officer being on a previously scheduled vacation at the time that you were taken into custody and arraigned, because that's what's triggered the date of this exam, was the date that you were arraigned. She already had an exam scheduled. That's good cause. I mean, a vacation schedule, that's good cause for me to adjourn. So I'm going to grant good cause and reset this.
Thank you, Your Honor.
You do April 10 at 10.
April 10th at 10. And so what you're saying is that the other officers are all here?
We have several officers present.
So I think there's a lot of counts here involving officers. 1, 2, 3, 4, behind. Assault resisting. So Miller, Kilborn, Bush, Leiter, and Booth. We're all.
Miller is actually the Booth that I'm referring to.
Got it. Okay, wait, no, there's 2 Booths, so maybe they're both on vacation. They might be on vacation together. Is Adam Booth and
That's
Caitlin Booth married?
I think that Adam Booth, I think that Adam Booth might have been subpoenaed by accident because Miller is referred to as both Miller and Booth.
No, Adam Booth is supposed to be here. He's count 7.
Yes. Oh, yeah.
And Miller was from Booth or vice versa. In the email, it's definitely Booth. Her current, she was formerly Miller. She is Booth now. Detective.
That is correct.
Booth. They may be married. They may be on vacation together. Nonetheless, she's essential to the primary charged regardless. So the matter will be reset April 10th at 10 a.m. Any additional matters for the record?
Nothing for the people.
The only thing I would just add, Your Honor, take somewhat of advantage since there is going to be an adjournment and some time here. It will likely be my intention to file a memorandum of law in advance of the preliminary exam. I do think there is a unique issue here that I would tend to argue against from a legal and Fourth Amendment standpoint as it relates to the issues in this case.
Okay, so we'll look forward to the potential of your memorandum and then any response from the prosecution between now and then.
And is there a particular deadline the court wishes to propose for that as it relates to the filing?
I know you literally have like about 2 weeks before between now and then anyway.
My
So
intention would be to file it at least 1 week prior.
yeah, that would be helpful to give the prosecution time to make any response in writing that they wish to. Other than that, we'll address it at the time of the exam.
All right, thank you, Judge.
Thank you. You're all set for today, so thank you. And then we'll run Gary, what's going on with Gary?
Another example of us being really on top of things.
Wow, what is happening with you all this week? The prosecutor's office is completely falling apart.
Everything I touch dies.
Okay. On the record of the matter of the state of Michigan versus Jerry Gary, 26-00579.
Ross Martinez for the people.
Aaron Robinson, Assistant Public Defender for Mr. Gary, who's downstairs in the lockup.
Okay, this is the date scheduled for a prelim on retail fraud first degree with a habitual offender fourth offense notice. How are we proceeding?
So, Your Honor, Mr. Gary has 4 counts of first-degree retail fraud. These were originally 4 different LPD reports that were consolidated into one case. And it yesterday, Ms. Robinson informed us that she only had security videos from one of the incident. Long story short, it turns out that discovery was only conveyed on one of the 4 LPD reports. So the defense only has discovery on 25% of this case, which I believe constitutes good cause to adjourn the matter so that they can review the other 75% of the discovery.
Wonderful.
That's correct, Judge. We'd ask for a good cause adjournment.
Good cause is granted. April 30th at 10. I'm assuming he's being held on something else.
He's got multiple matters, Judge.
Bond will continue. Any additional matters for the record?
Nothing for people.
No, Your Honor.
Okay, and then what's going on with Adrian Person?
He wants to run his exam, Judge.
Okay, we'll have him brought up. on the record in the matter of the state of Michigan versus Adrian Person, 25-02220 appearance.
Ross Marchmina for the people.
Aaron Robinson, Assistant Public Defender for Mr. Person, who is seated to my right, and we ask that he be allowed to remain seated for the hearing.
Absolutely. Today's date scheduled for a preliminary examination. This is for motor vehicle unlawful use. So we are ready to begin the exam.
Your Honor, this time the people have decided that we will not be pursuing this high court misdemeanor charge in the circuit court. And so we would move to amend the complaint and amend the charge to a first offense ordinary misdemeanor charge. So that we can have the case remain in district court.
You're gonna amend to what?
A first offense joyriding. I believe that's a 93-day misdemeanor.
At this time, is there any offer or is that the offer because of?
Well, we initially had offered a 90-day misdemeanor, most likely a disorderly or something like that. Defense at this time has not accepted that offer. We'll decide when it reaches district court docket whether or not we want to re-extend that offer or make some sort of.
Make it your free trial date.
Through March 31st at 1:30.
March 31st at 1:30. Any additional matters for the record today?
Will the court need the people to file an amended complaint? I don't know what the nature of this charge.
So, I just put amend, it was amended, so I think. it
Okay,
was-
yeah, it's perfect. All right, thank you.
The clerk might need a amended complaint.
Okay, we'll file an amended complaint.
Thank you. Okay, I think that's our criminal docket today.
And Judge, we'd also like to address bond if possible. Since this has been amended down to a misdemeanor, we'd ask that Mr. Person be allowed to be released on the PR bond. He does have an address where he can stay at, and we would ask that he be allowed to be released.
He has another matter pending with JMO.
He does,
He's
yes.
on bond with the bond.
That's correct.
He does have a bond on that.
Yes, he's already posted that bond. That's correct.
The issue in this matter is that the defendant previously had a 3,010% bond. He was supposed to appear in court on August 8th, but then didn't appear. And so how do we ensure he's going to appear for his future court dates?
He is on tether on the district court case,
Which district?
or I'm sorry, the circuit court case.
Oh, okay. And the address you have for him is on Jolly Road.
What is the address?
4220 Pleasant Grove Road.
42240
Yes, ma'am.
Pleasant
Grove
Grove
Road.
Road.
Lansing, Michigan, 48910.
Okay, just a week ago, you gave the address on Jolly Road. Why?
But I won't be able to stay by myself now. I had to stay with some Trent Sam.
Okay, what's your phone number?
870-319-8567.
You didn't give 870-316?
316.
That's it?
Yes, ma'am.
Okay.
8567. Right.
Bond is amended to 500 personal recognizance. You have a court date on the 31st, okay?
Yeah.
Any additional matters for the record?
Nothing for the people.
No, Your Honor, thank you.
Thank you.
It's in the same statute. Is it? Okay.
Or they asked me if I want to quash a warrant. There's no warrant.
Yeah, it's, however, in case of a first offense.
That file is, I think it is a warranty status. I think Nathan was saying that she doesn't know if they can,
All to the
because
trial.
it was, Is it what?
Who put it in warrant status? That's how they are. There's no,
Sorry.
oh, because you need a complaint and warrant
Oh,
issue,
guys.
you mean?
But seriously, I gotta
That's
say-
all we got is a complaint and warrant issue.
What's the case number?
It's 24-00026.
No arguments.
I know she was saying that,